Okay, so let's start talking about the court system. Now, when we talk about the court system, first thing we need to talk about is the players. You know, who plays right field, left field, center field, etc., etc. Well, in reality, let's talk about the judges and the justices. Judges, typically you're going to see judges at the trial level. You'll see justices at the Supreme Court level. Now, what do judges do? They sit on the bench, they wear cool robes, and they make decisions. Sure. No, they determine rules of law for a case. So we got He-Man. He-Man, the most powerful man in the universe. He's going to be our judge, right? Now, he's going to determine the rules of law for the case. Cool. Now, if there's no jury, he'll be the fact finder, and he will render his decision dealing with people in conflict. Now, justices deal with issues of law on appeal, and that's the most extensive power there is. All right, so you have judges at the trial level. The appellate level, you'll have justices, but here's He-Man, he's a judge. Okay. Who else? You may have jurors. All right. Now, you all probably heard this thing about having 12 jurors, and they are the fact-finding body. Now, usually you need to have 12. However, there are provisions out there that allow for smaller juries. Sometimes you don't have to have unanimous consent. It just depends on the state and the statute that supports it. Now, they give a decision. Again, it usually has to be unanimous. No reason has to be given. It's just, hey, we found the defendant guilty or not guilty. But with jurors, you have to think about it. They're 12 individuals. All right. So, as a lawyer, you got to help pick the jury, and that's called voir dire. Now, when you pick the jury, you got to try to read people, look at information, and determine whether or not they would be good for your client or biased. So keep that in mind when you think about jurors. Now, along with jurors, we have lawyers. Cute and innocent little fuzzy bunnies. Lawyers. Yeah, I happen to be one of these too. Now, they have a duty to administration of justice, but we also have a duty to our clients. Now, they're required in most states, or in most cases, and certainly my advice to anyone would be, if you have a legal situation, yes, you need a lawyer. They are representation advocates, meaning that we advocate for our client, and certainly this is a good thing. What you want is an attorney that's going to fight for you. You want an attorney that's willing to go to trial. Certainly, I'm willing to do those things. I think it's important that you advocate for your client. They're counselors, advocate, public servant. Again, all of these are traits that are vital to an attorney. Serving the public is a huge thing. Trying to help people out is something I do every day. Now, some of you may think, well, that Mike Childs, he's a no-good, low-rent, backstabbing SOB. Thank you, by the way. But at the same time, I really do want to do what's right. I try to save my clients money. I try to get them what they want, but I also advise them that sometimes they won't get everything they want. What's also interesting about attorneys is that communication you make with them is confidential. That's attorney-client privilege. And that's a pretty big thing. Would you go and talk to your lawyer if he could go and tell everybody else what was going on in your life? Certainly no. So, having that communication protected is a huge thing that most clients like. Now, once you know the players, you got to talk about what people do, or what courts do, and that's when we talk about subject matter jurisdiction. Now, jurisdiction is the power of a court to hear a case. Now, when we talk about subject matter jurisdiction, that's going to be the power of the court to hear that particular subject matter, that particular item. Okay. Now, state courts, their authority will come from the state constitution, state legislator, court rules of procedure. When I say state courts, I don't necessarily mean an area court. I mean that courts on the state level. So, great state of Tennessee, great state of Georgia. And within the state courts, you're going to have different tiers. Now, you'll have your trial courts. Parties file their lawsuits or complaints seeking to protect their property rights or redress for wrongdoing. So we got Leonardo here and the cute and fuzzy bunny who was a lawyer. Now they're going to be in a fight. They're fighting. And whatever. Leonardo beats the heck out of the Cute and Fuzzy Bunny. Now, the Cute and Fuzzy Bunny has been injured, so he's going to file suit against Leonardo. Okay. Now, where's he going to go? Well, depending on what happens, he could go to small claims court. If this is a small matter, if the Cute and Fuzzy Bunny has a broken arm, he'll sue Leonardo for damages. So, small claims court will handle a lot of litigation between businesses and customers. Small matters. Now, the benefits of going to small claims court is it's informal, low court costs, and simplified procedure. And again, this may make the parties at small claims feel a little better. Now, keep in mind there is a dollar limitation generally on this. Now, if you go above that dollar limitation, then you might not have a small claim. You may need to go to the next tier up, maybe Superior Court, whatever it is for Tennessee or Georgia. Georgia is the Superior Court. Now, you go through the trial court, whether it's small claims or Superior, State, Magistrate, whatever, and let's say you don't like the decision. Well, you have a right to an appeal. Now, you could go to the appellate courts, and generally by right you have the ability to go to the second tier of appellate courts, and they'll review the decisions at trial. Now, keep in mind the appellate court stuff is not what you see on TV. What you generally see on TV will be trial court information, but at the appellate level, generally you're going to be in front of 3 justices, and your attorney is going to be arguing matters of law, not fact. At the trial level, you would be arguing facts, but at the appellate level, you're going to be arguing the law. Like maybe the law was misapplied at the trial level. You made an objection, the judge made an error, should have granted the objection instead of overruling it. But that's what you do at the appellate level. Now, if you're still not happy at the appellate level, you can go to the state Supreme Court, and this is going to be the highest court for the state. Now, you have to get there by writ of certiorari, meaning that this is the procedure or the documents you have to file to ask the Supreme Court of the state to listen to your case. And again, it's an appellate level, and again, you're going to be arguing law, not fact.